All right, good afternoon, everyone. Thank you for taking time out of your busy day to spend time with Kristen and myself, Christopher Cahill, to go over the essentials of legal documents, what you need to protect yourself. So Kristen, take a moment and introduce yourself to the fans here.
Sure. My name is Kristen DiZallo. I'm an estate planning attorney at Eckert Byrne, and we are a life and legacy planning firm in Cambridge, Massachusetts.
Excellent. And recently named partner. Congratulations again. That's really exciting.
Thank you.
And as Kristen indicated, her practice is centered around trust and estate planning, probate administration, and certain trustee work. And this is all that she does.
Yes.
So I'm pleased to be here with you today.
Thank you so much for having me.
So we're going to talk about estate planning, everybody's favorite topic. Just kidding. Nobody likes talking about this stuff except for you and I.
Exactly.
So, you know, getting documents done, it's one of those things that people feel they want to put off for as long as possible. But generally speaking, it's best to kind of get in, get out, and then pay attention to it and monitor it as we go forward, correct?
Definitely. You don't want to be an ostrich with your head in the sand and just avoid things. Not having documents in place is much, much worse than just taking the time and maybe putting out a little bit of money to make sure that it's done right, to have things in place. It's just very good for peace of mind.
So true, and for the family in general. So we're going to talk today about the basic documents that one needs. So what you're going to see here on this screen is we're going to talk about living trusts, also known as revocable trusts here in Massachusetts. We're going to talk about wills, pour over wills into trusts, powers of attorney, healthcare proxies, advanced medical directives, etc. So without further ado, let's talk about the linchpin of most estate planning, living trusts, right?
Yeah, they're amazing, amazing documents. Living trusts, I think, are often misunderstood and really underutilized with a lot of people because people think of trusts as that means wealth. You have to have a lot of money
Absolutely.
To make it worth setting up a trust, and that's just not necessarily true. Trusts are very useful for dealing with disability and for death planning, and that's what we're talking about when we talk about estate planning, those two big concepts, disability planning and death planning. So things that people don't love to think about. But if you can just remove the fact that you are going to pass away someday, because that is just reality, and remove the possibility that you could become disabled, don't think about the event itself.
Right.
Think about just setting it up, having a plan in place, and it's really to protect your loved ones and to protect yourself if you're still alive and you're incapacitated. So a trust is just an instrument that you create during your life while you have capacity and while you're well, that outlines what happens with my property when I become incapacitated, what happens at my death, what happens when my spouse passes away, and you just set up that plan and that flow and that roadmap. The trust is revocable by you, so what you put in place now is probably not going to be the same provisions you'd want in 10, 15 years, sometimes even 6 months later. So think of it as a reflection of you right now. What makes sense for you right now? And then you can always amend it.
Perfect, perfect. And your point about the disability is something that I think is often lost with many folks is they think about a living trust or a revocable trust as a pure estate planning document. But really, it's a lifetime planning document as well, because if you become incapacitated, using the trust to have the management of your assets is far superior than having to rely exclusively on a durable power of attorney, for instance, or worse yet, having neither and leaving it to your heirs to go to court and get guardianship and orders to manage the assets for you. So the trust is a really flexible document and one that both Kristen and I really think is important. Irrevocable trusts are like the Mac Daddy of these trust documents. They're more robust, typically. They're by their very definition irrevocable, meaning you set them up and you typically, on the face of it, it sounds like you can't change it, but there are certain things that you can do. Right?
You can. We always build in ways to make it flexible. So it might be irrevocable, but it's not inflexible. So they are not set in stone necessarily.
And when would one use an irrevocable trust?
It's usually used for tax planning purposes.
Estate tax purposes.
Estate tax planning purposes, exactly. So whether it's for life insurance, if you have a sizable amount of life insurance that you want to take out of your estate for tax planning, leave to your spouse and kids tax-free. We use them for gifting trusts. If you want to start gifting to your kids and maybe you don't want to just give them a check, you can gift them with having some oversight within a trust. For people who do Medicaid planning, elder law planning, which I don't particularly practice in, but they are very common for those situations. It's really to remove an asset out of your name.
Yep.
The living trust, the assets are still part of you. There's no asset protection. There's no tax savings with a revocable trust. It's your social security number. There's no separate taxable entity. With a revocable trust, they are typically to try to remove some aspects and control so that it's not part of your estate for tax purposes. It may still be part of your income tax, so there's a lot of complexities with the irrevocable trust of how they're taxed, but they're typically seen for estate taxability.
And one of the big things that we see them used for is really to protect assets, right, when you think about it. So protect assets for your spouse, your children, your grandchildren, your heirs, the ones that you care about, from those big scary things like divorce, creditors, right? If they happen to be in a particularly litigious business, if they're a surgeon of some variety, a heart surgeon, and they could get sued. Literally having assets in a trust with a trustee that can direct them saves those assets for them in the event that they do find themselves on the wrong side of a lawsuit.
Definitely. Right? It's the greatest gift you can give someone is protection. So asset protection, divorce protection, and the only way you can do that is through an irrevocable trust. And even if your revocable living trust is set up as a revocable trust while you're alive, when you pass away, it will become an irrevocable trust. So you can provide those benefits through the trust to your kids and have little sub-irrevocable trusts set up for their benefit. So it's a really, really useful tool.
Little baby trusts.
Yeah.
So wills, right? This probably should have been the first document. This is really the beginning of most estate plans, right? The will dictates where the assets go, who's in charge of the assets, and most importantly, who the guardian's going to be for your kids, right? And that's the thing that'll bring people in the door at first. When they're coming in the first time to see you, it's more often than not the young couple that just got married and has their first child on the way, right?
Often. But as we've talked about before, guardianship designation is one of the most contentious areas to decide. So sometimes it makes people stall planning because they can't decide. And then they come to me once the kids are grown, because then that's not a fight on the table anymore. I don't suggest that approach ever. But
that's a really lousy estate plan. I don't want to think about it.
Exactly. But it is a huge driving factor. Once you have kids, people then realize they need to make plans of what if something happens to them. And the will is where you're going to designate that guardian for minor children. So whether you decide to pass assets through ownership, co-ownership, beneficiary designation, under a trust, however you pass assets or your plan, you still always need a will as a backup. So if you're using the revocable trust as the primary means to distribute property at death, you still need a will to catch any property that passes through a probate court. And then you need to be able to name a guardian. If you have children under the age of 18, you need to have a will for that purpose.
Certainly. And your point from a moment ago is really important. Many assets won't pass through a will, right? So your individual retirement accounts, your IRAs, your 401ks, qualified plans that are beneficiary designated, those will go to the folks that you name. So that won't hit the will. The stuff that's in the living trust, the revocable trust, that won't go through the will. The joint properties, the joint bank accounts won't either. So in many instances, people can delude themselves into thinking that the will is really handling a lot, when in point of fact, it might not handle anything.
Right.
Right.
And certain plans, that's a great thing. We don't want it to.
Right.
We want to bypass probate. We want everything to be private. Anything going through the courts, public.
True.
If you have a will-based plan where that is the primary means to distribute property, then having assets bypass the probate process is disastrous to your plan, because you've set it up that you say, I want everything to go to my children equally. Well, if you have only one child as a beneficiary on your retirement account, and you have added a child as a co-owner on your accounts for convenience purposes, you are that's in contrast to what you want under the will. So it's very important to understand what you have and how you own it, because that dictates how property passes.
Well said. Thank you. So a moment ago, we talked, I think, about at the very beginning about powers of attorney. So powers powers of attorney are really, really important documents. They can be utilized for all manner of things, but let's just talk about what you see powers of attorney being important for, where they come into being, and what they do.
So powers of attorney are very helpful in the event of your incapacity for legal and financial powers. The power of attorney dies with you. So this is truly a disability or lifetime document. This has nothing to do with having authority over you after you've passed away. So the power of attorney, I typically see them as general powers of attorney, which is just a catch-all. It's every power you could possibly need.
And if that would theoretically come into being immediately upon execution, so you would give that to, say, your spouse, and from that point forward, your spouse could take that document and go handle all manner of things for you.
Yes.
Which could be great if you want that. Could be a little dangerous if you didn't want that.
Exactly.
Right?
So the term general in a durable power of attorney just means it's general powers. Powers to buy, powers to sell, powers to deal with contracts. Then you're naming who you want to have those powers, typically called your attorney in fact or an agent. And then when do they get those powers? And if it's an immediate power of attorney, then that's exactly right. They immediately have that power to act on your behalf, which for a spouse could be very convenient and useful. If it's not a spouse and it's a child or an adult child or a family member or friend, maybe you don't want them having immediate access to those powers, in which case you can make it a springing power of attorney, which only springs into effect upon your incapacity. So we include these as quote-unquote incapacity documents, but if you have an immediate power of attorney, it's actually not tied to your capacity at all. It just continues on if you became incapacitated, but if it's an immediate power of attorney, it's immediate now, whether or not you're incapacitated.
And certainly limited scope powers of attorney, those are the sorts of things that if I was selling a property and I wasn't in town and I needed it to just get done, I could sign a document and have you take care of that for me, right?
Exactly. So you just set the parameters of it. It's to sell this specific property, and then it usually has an expiration date, only effective for 90 days. Or when we help with clients with their estate planning, if we're funding their trust and making sure their assets are changed in ownership to the trust, or the trust is the beneficiary, they don't want to deal with that. Sometimes they will grant the firm the authority to change and benefit those beneficiaries, but it's that limited scope. Other states refer to their healthcare proxy as a medical power of attorney. So it's important to understand that there's financial powers and medical powers. So if you're in another state, you might have a power of attorney that's for medical purposes. Here we call that a healthcare proxy.
It's a great point. Very, very good point. So speaking about healthcare directives and advanced healthcare directives and all, the durable power of attorney deals with finances. This is dealing with your health, right? So somebody becomes incapacitated and they can no longer make decisions. This document, properly drafted and executed, would allow the agent holder to be able to make those decisions, correct?
That's exactly right. So it needs to be someone 18 years of age or older. I don't typically recommend an 18-year-old to be tasked with that job, but technically you can name anyone 18 years of age or older. Typically spouse. Sometimes for various reasons, religious or otherwise, people don't name the spouse. But it's someone, and it's really just getting that person to have the authority.
Right.
No one inherently under the laws has the right, even a spouse, to make medical decisions on your behalf. You don't want someone to have to go to court to be appointed your guardian in the event of an emergency. So this holds true even for kids. When your kid turns 18, you want them to have their own healthcare proxy appointing likely the parents. So if something happened to them, parents could step in. And I've heard horror stories with parents being cut off from information about their kids if they've been in an accident because they don't have the proper authority. So it's just setting that parameter of who's going to make the decision. But there's not a whole lot of direction under that document, so you want to give supportive information to your healthcare agent so that they make the best decision on your behalf, and they're not just left to kind of say, well, I don't really know.
So how does one do that? I mean, clearly a conversation, a robust conversation is important, but at the same time, there's probably other mechanisms, right?
Definitely. So one thing is a living will, which is a document people call the pull the plug document. It's beyond that, but it's if you could not survive on your own without machinery, you were brain dead, you couldn't live on your own, and you were never going to recover, deemed so by doctors,
right?
Never going to recover is up to the doctor's input. But If you likely couldn't survive ever on your own, then you're telling your healthcare agent through that living will, take me off life support. Stop anything that's going to prolong my life.
Right.
You can give me comfort care, but don't do anything that will prolong my life. Although we do not recognize living wills in Massachusetts, there's no law surrounding them, they are direction to your healthcare agent. And if your healthcare agent sees that, it will give them peace of mind they're making the right decision. And that's usually, no matter what state you're in, how they're used. Your healthcare agent's going to do what you want them to. You've named someone that you trust. If it ever went to court, the hospital wouldn't take you off life support without a court order, then it's considered highly persuasive evidence. Or your healthcare agent could move you to a state that does recognize living wills. So although they're not legally recognized in Massachusetts, I still think they're important to have as that direction.
So you recommend that your clients sign them, even though they're not legally persuasive here in Mass?
I do. I've had clients share with me their stories of taking family members off life support and just seeing that document.
Traumatic, right?
It's hard enough to do it, but they go to bed knowing they did the right thing.
Yeah, no, that's a great point.
The other direction that you want to give your healthcare agent is just more specific circumstances. So just letters of instruction. So we give our clients a template, check the box, fill in the blank. In this medical situation, I'd want you to do this, and how you would want your healthcare dealt with in your 20s versus 30s versus 80s is all changing. So all of these documents are a reflection of you right now. As you change, as your life changes, circumstances, you want to update them. So you want to think about the letters of instruction regularly. And then that document can be provided to the healthcare agent so they can just get a general sense of what you would want. And I say at the very least, have a threshold for quality of life. What do you need to have quality of life? Whether it's a sport that you play, or it's something that you can watch on TV, or something you can eat, whatever makes you happy in life, share that as an absolute base with your healthcare agent, because when they're in the midst of having to make a decision on your healthcare, you're in the middle of surgery, that basic information can really guide them.
Wonderful. That's a really important point, and one that's often overlooked, certainly. So let's talk about getting access to records. This lovely document called the HIPAA Authorization.
Yes. So HIPAA, which didn't exist when we were young, which
True.
is why probably our parents never thought about these things, because they could just call the hospital and find out what's going on. No one seemed to really protect privacy so much. HIPAA makes it extremely restrictive and important to protect privacy. So you have to authorize someone to have access to that information. So we always build into our healthcare proxies HIPAA authorization for any agent serving, because you don't want someone to be tasked with making medical decisions, yet they're not allowed to talk to the doctor or get access to medical records.
And that can happen without that, right?
And I've seen old healthcare proxies. Having an outdated healthcare proxy from 20, 30 years ago never mentioned HIPAA because it didn't exist. So it's very important that everybody that's an agent have that authority to get access to information. And then you might want to have, what we do is we have a separate HIPAA authorization so you can build in other people. So if your spouse is the healthcare agent telling the doctors what to do, you may still want your adult children or certain friends or certain family to be able to call the hospital, find out what's going on with you in your care. That also relieves your healthcare agent, because if it's the healthcare agent constantly having to call the family, tell them what's going on, the burden on them, this just gives other people access to information, brings them into the loop.
Excellent. And that's, again, one of those things that is relatively new and definitely should be paid attention to. So as we talked about earlier, the will gives the ability to name a guardian. That's one of the most important things for young families, to know who's going to take care of your children. If you, for whatever reason, fail to execute legal documents identifying a guardian, the court will make that decision for you. That may or may not be the person that you would have chosen. So don't stick your head in the sand and become an ostrich, as we've talked about before. And really making sure that your children are protected. That's really what we're talking about here from the estate planning perspective. But from the interest of time, we're going to back into the world of prenuptial agreements. Now, I know you don't draft prenuptials yourself, but you certainly have colleagues, as I do, that are specialists in family law and all manner of work in this space. But I got to believe that you come across this stuff all the time. So let's talk about what a prenup is, why one would use it, and how one would use it.
So prenups are really similar to an estate plan, where the law is set up to say who gets your property when you die. The law is set up to say how your assets are divided upon a divorce. And each state has their own criteria for that division. So the prenup is just acting to establish before you even get married, if this marriage ends in divorce, how are the assets divided? What are the spouse's rights to those assets, to alimony? And it deals with how those assets are distributed in the event of the divorce, but then also at death. It's not that you get an automatic right to assets as a surviving spouse, as the law provides. It says maybe that you don't get that right. So prenups are very circumstantial, they're specific. Sometimes they'll give a certain amount of assets to the spouse over a time period.
Right.
They have to be reasonable. Massachusetts has pretty strong prenup laws, but they shouldn't be last minute. You don't want someone to claim it was under duress. I only signed it because my whole family was flying in out of town and it was presented to me the night before my wedding.
Yeah, those will never stand up.
No, you want to do this ahead of time, thoughtful, both sides having an attorney.
Full disclosure of
assets. And it doesn't have to be for everything. You know, some clients come in, I've dealt with clients where they both come in and they have prenup that solely protects inheritance.
Yeah, or the family business, whatever it may be. And that's a great way to address it because it becomes less confrontational.
Exactly. So it's, you know, when you get married, it's a contract. And very few people sign contracts without negotiating them or without looking at an attorney. So you can just see a prenup, it's just a contract negotiation. That is all it is.
So true.
So I see clients coming in who have prenups already, so we need to make sure that their plan is aligned to that goal of that prenup. And a lot of our clients will force a prenup onto their spouse if you were to pass away.
So how would you go about doing that? Let's talk about that first.
So if you have a spouses that come in, say it was you and your wife.
Yep.
You came in and you both have children together, you built your wealth together and your life together, and you say to your wife, if I died, of course I'd want you to move on. I'd want you to get remarried, I'd want you to love someone again. Maybe you wouldn't, I do hear that too. Most people want their spouse to move on.
Certainly.
They want to say, well, if you move on with this new person that I don't know, I've never met, obviously, well, hopefully you've never met them. I have heard of that as well. That if that new marriage that your wife entered into ended in a divorce, you just want to know that the assets you've built as a family are going to go to your kids.
Stay in the
and
family.
Not be divided and go to some new family or new person. So you can build into the revocable trust, and the trust that banks off money for your spouse. They can use it during their life for their needs. They have control over it, but they need to have a prenup at least 90 days before remarriage to protect those assets.
And that's so smart. That really does protect those assets. It protects them.
It protects them and your kids, and it's a really nice out because you're dead, so they can totally blame you. Your wife can blame it on, blame it on my ex-husband. He's forcing this prenup, and it kind of takes away that off the surviving spouse to have to approach that conversation. It's just already outlined now. And then we also see them for kids.
Yeah.
Kids who get married, they get an inheritance, and then they lose half of that inheritance to a divorce.
Yeah, we've all seen, and sadly, that's so prevalent these days. So that's where the whole art of planning is really to preserve and protect the assets for the next generation and future generations. So, protecting them from those creditors and predators that are out there in the world that we're also familiar with.
Exactly.
So, coming to see an attorney can be a scary thing for many people. Certainly shouldn't be.
No.
Isn't out here.
We're lovely here.
So true. So my suggestion is that this is one of those things when people tell me that I've been thinking about it, I just don't want to do it or whatever, I always tell them, listen, having it hang over your head is far worse than just getting in and getting it done, right? So get in, get it done, and then pay attention to it. You don't need to look at it every month, but certainly I know that you recommend doing this on a pretty regular basis, right?
Yeah. I mean, you really should take the same approach that clients take with their financial advisor. I know it's a little easier to talk about finances if the market's good at least. And you check in with your financial advisor at least every year.
Yep.
You need to make sure that he's there, the advisor's on top of what your goals are, what your concerns are, and that your assets are managed properly. It's the same thing with your estate plan. Taking an annual approach just makes sure that if there's been any changes in your life that they're addressed, and if there's any legal or technical changes in the law. As I mentioned before, super old healthcare proxies didn't have HIPAA authorization.
That's right.
You, as the person who created that healthcare proxy, aren't supposed to know when the law changes. That's why you have a lawyer. So if you don't go to your lawyer for 15 or 20 years, you have no idea what's been out there that's changed, that's made your plan no longer effective. So having an attorney involved and looking over things regularly can really help to make sure that your plan's running the way you need it to.
So well said, Kristen. Thank you for your time this afternoon. Really, really appreciate it. As we spoke about a moment ago, Kristen's a partner at Eckert Byrne here in Cambridge, Massachusetts. Why don't you tell everybody your phone number and your email address, Kristen?
Sure. My phone number at the firm is 617-453-9001. And then you can also reach me by email, which is my first name, KRISTIN, at Eckert Byrne, ECKERTBYRNE.com. And then you can also visit us at our website, which is the same as my email, so www.eckertbyrne.com. There's a lot of useful information. If you just want more information about estate planning or how we approach estate planning as a firm, definitely head to our website. There's a lot of good information on there as well.
Excellent, and thank you. And speaking of websites, this recording will be posted to the 12 Points website, and there you'll also be able to find the upcoming webinars for balance of 2018. So thank you all for joining us today. And Kristen, thank you.
Thank you so much.